Yes, Mrs. Beck, we were going to move on to the judge's construction.
The third construction, that's right. The third one in play, I've just got to, although as my lords and my lady understand, neither myself nor my friend like this. And the judge's construction, by that I mean the one that's applied in the latter part of the judgment. He doesn't require a step of limiting the data that's being multiplexed to the size of the ETFC, which is the next smaller ETFC, i.e. next smaller to the sum of the grants. And he doesn't require means to apply that limit in the apparatus claim either. As I said, I think before the short adjournment, my friend recognises that this is not really meaning limiting at all in paragraph 18 because he seeks to distinguish his construction as actually meaning limiting. All this claim requires is any procedure, and therefore any means that give effect to the procedure, which can produce a result where the multiplex data is in fact within the size of the next smaller ETFC. In other words, unless one can say an old procedure ensures it will never result in multiplex data that fits in the next smaller ETFC, it's covered from the mere fact that on occasion it might do so. That's the judge's construction. And so the old system as it stood before InterDigital's contribution is within it because it doesn't guarantee or ensure the multiplex data is never of a size that fits in the next smaller ETFC, as we've seen in the special case illustrated in DXX14. There are a couple of important points to understand about this. First is a point that I foreshadowed, I think, in a response to a question from my Lord Justice Arnold earlier. This is a kind of undistributed middle point. There may be those procedures that ensure multiplex data is of a size that fits in the next smaller ETFC, therefore ensuring a larger ETFC is never used when the procedure is deployed. We say that's what the patent's directed to. That's at one end. There may be those procedures that ensure the multiplex data is a size that does not fit in the next smaller ETFC, so ensuring a larger ETFC is always used when the procedure is applied. The other end. And then the undistributed middle is those procedures that simply don't ensure either. When the procedure is used, it's possible for the multiplex data to be both small enough to fit in the next smaller ETFC or too big. And that's the undistributed middle. And really the fight is, when it comes to defending the judge's construction, is that we say it's the first category, those that ensure a larger ETFC is never used. And I do point to the fact that my friend agrees with that's what the invention's about in his skeleton. We say it's limited to achieving that. But of course the judge's construction lumps that undistributed middle into the claim as well, thereby only excluding those that ensure the opposite when the procedure is applied. The next point is that this is not the same point as requiring the procedure to be used and the means that give effect to it to be used or deployed in every TTI. If you do something else in another TTI, obviously you're playing by different rules. What the claim's directed to are procedures that ensure that when you do it, you don't end up using an ETFC that's bigger than the next smaller one. The question of whether you are or are not required to do it repeatedly in every TTI is just a different dimension. And that is in fact why my friend has had to revive his construction, put it on the table as a third alternative. That's why it's not a squeeze at all. You've got just two different dimensions moving away from what we say is the proper construction, each going to the two constructions that I say are wrong. The second important point is this. And again, this is touching on something which I think I foreshadowed in an answer to a question from my Lord Justice Arnold. The thing that the means need to do in the claim is apply the steps in the procedure. As I've said, it doesn't matter how they do that, but they must be means to do that. It's not satisfied simply by it being means that can, on occasion, ultimately end in the same PDU, in the same ETFC being sent out the door, as might have been arrived at if the procedure is used.
Say that last bit again.
It's not simply being means that can, on occasion, ultimately end in the same PDU, in the same ETFC being sent out the door, as might have been arrived at and ensured if the procedure is used. The point is that you can get the same result by following different rules sometimes, and that does not mean that you have means to apply those rules. If we go back to the simple example that I postulated to my Lord about the means of restricting entry to a fairground ride, if you have to pay the money and buy a ticket and also have to fit under a bar, you are ensuring that everyone's under the bar, under the height restriction. If you don't have that, some people that go in may still be under the height restriction. You've got a result of a person that's under the height restriction, but you haven't applied any means to limit the height. And you don't ensure, you don't apply the means, you don't ensure that you're getting people that are under the height limit. And so in this respect, the difference between myself and Mr. Abrahams on the one hand, and the judge on the other, because in this respect, Mr. Abrahams, Lenovo's construction of mine is the same. I don't require it to be done every TTI, but we do require the limit to be applied. The difference between us together and the judge on the other hand is that the judge is not identifying the right result when he says the claim is generally something that merely requires a result to be achieved. And this definitely is the point that I gave my Lord in response to a question. It's not the right result. He's quite right that it's means to a result or a thing, and it's general in that sense. But one has to understand that the result that you have to achieve is the application of the step in the procedure at the level of generality in the claim. In this case, the step of using the size of the next smaller ETFC to limit multiplex data. It's not directed to the means simply of ending up with multiplex data that is of a size that is smaller, but you haven't actually applied the steps of the procedure to get there. And this is actually related to a point as to why my friend is so averse to looking at Claim 5 together with Claim 1 and giving them a construction that works for both. Because the judge's construction just ignores that the substance of the invention is a procedure, and that by applying the limit of the claim ensures a body of data that always fits in the next smaller ETFC, so ensuring you don't use a bigger one. Instead, the judge looks to see if any other procedure ever could, on occasion, result in a body of multiplex data that fits in the same ETFC, even without positively applying the limit which ensures it. And it doesn't come close to even seeking to explain how the construction works for the method equivalent. In fact, it just doesn't even try to. Those are the rival constructions on the table. As I've said, neither myself nor my friend favour the judge's construction, at least as regards my friend for his primary case. he does say that it's better than my construction. I think I've given, my lords and my lady, quite a flavour of why I say my construction is right. Can I just now move to a kind of miscellaneous section where I deal with a few other points covered in the skeletons, pick up. The first is this point I foreshadowed already. The claim represents no improvement at all if construed as the judge did at the end of his judgment. And that's of some significance in this case because the reader would not ordinarily expect the patentee to have framed its claim to cover the very thing to which the invention is supposed to be an improvement over. The point that I'm making is similar to the well-known dicta in the Virgin and Delta case, where it said that one doesn't ordinarily construe a claim as covering something the patentee acknowledges as old. And of course, that point doesn't run in cases where some piece of prior art's been found that one has no reason to understand the patentee had in mind. But the reasoning and the sentiment underlying it does, we submit, in our case, where the thing that everyone was working on and the thing that the patent is supposed to represent an improvement over, everyone knew about. It's actually supposed to be an improvement over the specification, and that consideration does come into play in my submission. And my friend rather recognises the force of that point and seeks to diffuse it in his paragraph 34 of his skeleton. He claims that the argument points to Lenovo's construction. Well, he's right in this sense, in that his construction doesn't cover the old system. So it's not susceptible to the same criticism. But that's because his construction is our construction, which also doesn't cover the old system, but with the additional restriction of requiring the means to be applied 100% of the time. So in my submission, it doesn't point to his construction. So his answer is no answer, but he is recognising the force of the point. That leads me to the point my friend makes in his skeleton about what if things were set up so a mobile used a different procedure 99 times out of 100, and that different procedure ends up with larger ETFC being used. There are several answers to this point, my lords and my lady. The first, his position is that the apparatus and method claims have equivalent scope. Shown you that. So how does he deal with the point as to what would still be multiple infringements of the method claim? Point made by the judge, you will recall. He doesn't, save to say, please don't think about the method claim. He just doesn't deal with it. The next point is that all this argument amounts to is the familiar point that one could set things up to infringe in a less well manner than other ways you could set it up. It's never a successful argument because it leads to an argument that you must infringe in a way so as to get the maximum benefit that the invention may offer, even if there are circumstances that might mean there are countervailing reasons not to. And my lords and my lady will have seen that we point out in our reply skeleton a situation that's real life, and I touched on it in responding to a question from my Lord Justice Lewison. What if, for many transmissions, say most mobiles, most of the time, you do want to take advantage of the efficiency the invention gives across that population, but you might want the ability to opt a mobile out some of the time because there's a countervailing consideration. That's exactly the case with the special case of transmissions which are only non-scheduled data. As I explained this morning, that data is often urgent. I gave an example of the small quantities of VoIP data that should not be held up. So a reduction in the data sent when you've only got that data, which is time critical, is not a good idea. On my friend's construction, you would not be allowed to do what you would want to do, which is to be able to opt a mobile out in those circumstances. You want to opt a mobile out because you don't want any reduction when it's only 100% non-scheduled data. But that doesn't mean the invention is not of use, nor that it can't be taken. And accommodate that ability to opt out. I'm quite happy to take my friend's 99 out of 100 the other way round. Just think about that. Assume 99 times out of 100. You do want the mobile to be using the procedure of the patent. Say that that's the proportion of times. You decide that you don't when it's only non-scheduled data and it's a 1 in 100, whatever it may be. Say you've got a cell of 500 mobiles. So on average, in each TTI, about 495 of them would be operating the patented procedure, which ensures that in 495 of them, they don't use an ETFC that's bigger than the next smaller ETFC. One gets the benefit of the increased efficiency across that mobile population, 495 on average contributing in each TTI, but 5 on average are opted out. Of course you're taking the invention.
Can I ask a question at this stage? The opting out scenario comes from the way that the standard operates, if I've understood.
The way it arises in real life is because of that. I'm postulating that you might consider to set up a system, but yes.
If you are construing the patent itself, is the standard of relevance to that exercise? In other words, you can't
not
say...
the particular standard, no. But the point that I'm illustrating is that it's quite obvious that you might expect that you would not necessarily want to do it 100% of the time.
No, I follow that.
That's my point.
But you don't. You say it's not legitimate to say, well, the patentee must have wanted this patent to fit into the way the standard
No, and
works.
indeed that's a point that my friend tries to argue that I'm going to come to. It's not legitimate to try and look at a standard and say I'm going to construe the patent with the details of that particular standard in mind. And I don't want my lords and my ladies to understand that that's what I'm trying to do. I'm trying to illustrate that you would expect that circumstances might arise where you'd want to do that, and the standard is a real-life example where that's happened, but not that I'm saying because of the standard. I hope that's clear. Yeah. But just returning to that example, you're still using the invention and getting a huge benefit across the average population of 495 out of 500 using the procedure. But you're also allowing individual mobiles to be opted out on an occasion where there's a special reason to do so. And all that means is that you don't have to use the procedure 100% of the time, but when you are, you're still using it. Now, my friend goes on after his 99 out of 100 example paragraph, 32.1, I think, to suggest that the Filiotrope prior art ensured that an ETFC larger than the sum of the grants is not used in some scenarios. Worth looking at. So it's 32.1. Sorry, 32.1 is the 99 out of 100. 32.2 is the point that I'm now on. Well, remember the Nazi tied himself up in the language between 26 and 27, where he merely said Filiotrope was able to produce the result of not using an ETFC larger than the next smaller. Biliotro does not insure it in any sensible use of the word insure. It can happen on occasion, but one cannot control when that is. It's just a result that sometimes gets thrown up because of the circumstances as to where that dotted red line happens to be very close to, but just bigger than an ETFC. Doesn't insure it. My friend is right in paragraph 32, little 2, to criticise the judge's construction as covering devices that never, in any scenario, in any TTI, use less padding than the prior art. That's just my point that I made earlier. He's right about that. It's a massive problem with the judge's construction. But we can't understand why he says in that paragraph that it's so for my construction. My construction allows a mobile using the procedure, i.e. deploying the means, to ensure that an ETFC larger than the next smaller ETFC is not used. The prior art doesn't do that at all. And his third point's likewise wrong. He's just putting the previous points together, but it's wrong because his second point is wrong. Simply wrong as regards my construction. Can I now move on and just make sure my lords and my lady have on board my specific answers to the 5 points he seeks to make as to why my construction's wrong? These are the 5 points advanced at paragraphs 23 to 28. I've covered the ground, but I just want to draw it together to make sure you've got it all on board. The first point, so this is his paragraph 23, is the argument that there's no specific procedure required and a suggestion I'm seeking the right words in the claim. We agree there's no specific procedure, but one does need to be doing what the claim refers to at the level of generality of the claim. Both the method claim and the apparatus claim, it's the same. Applying the step of limiting the multiplex data to the size of the next smaller ETFC. His second point, paragraph 24, he suggests the claims would be expected to be drafted towards a result, not a procedure, as the standard is only concerned with what a mobile is or is not allowed to transmit, not matters of implementation. But my construction is precisely concerned with what a mobile is or is not allowed to transmit. The claim's directed to providing a procedure that ensures the mobile doesn't make a transmission using an ETFC larger than the next smaller ETFC, but it's applying the procedure. It's exactly what the standard would be expected to be concerned with, because it has to provide a regime that sets out rules to control the level of each mobile's transmission, therefore the overall transmissions in a population of a cell, the reasons that I explained to my lords and my lady at the beginning. It's exactly what you'd expect it to be concerned with. So not only does this point not help my friend, when properly considered it's against him. Third point, paragraph 25, this seems to be an argument that the skilled reader would understand the patentee not to have intended the claim to mean what we say, because it wouldn't be essential and would therefore be of little commercial value. Now, my friend is wrong about this on two levels. First, his suggestion that it's not essential is wrong, but in any event, it's a bizarre argument to ask the court to construe the patent having regard to a perceived commercial value or not arising due to the standard settled after. That's the point that I was foreshadowing in answer to my Lord's question just a few minutes ago. We say you don't do that. Fourth point, this is paragraphs 26 and 27 I've dealt with already, and the lacuna we see in the language, the sleight of hand going on there. And the fifth point, the argument about the variety of specific methods I've already addressed. The point, properly understood, helps my case. There are a variety of methods, but all of them involved using the ETFC as a limit. That brings me to the question of infringement. Can I say a word about that? My friend seeks to say that if my construction is right, I must be saying there's some specific procedure. And that's the basis, as I understand it, for him saying therefore is not essential. We saw his paragraph 28 where he points out that the variety of specific methods set out, a variety of specific methods are set out in the patent, and therefore there's no limitation to any such implementation. We agree, as I've tried to explain. He returned to that and seeks to put forward words in my mouth and say my construction is there must be a specific procedure. You see that in paragraph 47. And I hope, my lords and my lady, grasp how I say one can require the actual application of the step of limiting to the next smaller ETFC size without also requiring a specific way to do it. Paragraph 50 of his skeleton, the same points made again. He says that we now contend claim 1 requires a specific procedure, and the suggestion is that there's no infringement. This paragraph also seeks to argue that our case as pleaded is now accepted to be wrong. He sets out some words and says it's common ground, this is wrong. This, as I understand it, is specifically because of the reference back to paragraph 35.
So can I just make, I'm not quite sure that I've got the context of all this. If you lose the appeal, then the judge's order stands.
Yeah.
If you win the appeal, what happens about infringement? The judge didn't get to infringement.
Oh, he did.
Did he? Because he revoked the patent.
No, but he dealt with infringement earlier on and held that it was infringed, but he said that it...
well, he said on Lenovo's construction it wasn't.
Yeah.
No, it's dealt with at 186.
186.
If the patent is valid, then Lenovo's identified devices infringe and the patent is
right.
essential.
Right. Okay. Thank you.
I mean, the sentiment that my lord's raising is, should I be dealing with this now or in response? Because it's...
Well, I don't mind.
Yeah.
It suits you better.
Well, I was planning to set out what I say about this now.
Yeah.
Certainly what I understand him to be saying in 50, where he suggests that I'm somehow accepting that our pleaded case is wrong, and the reference back to 35 is seeking to argue that we're advancing a case that there can be no exception in any TTI. That seems to be the thrust of 35. The trouble with that is, my friend, what he's doing here is taking some words in the pleading that explain the effect of words in the standard. Words in the standard obviously have to be implemented, programmed into the device. And the words in the standard plainly only apply in the case where there's scheduled data, i.e. when it's not, sorry, when it's, not when it's only non-scheduled data. So just to meet the point, can I just show you the whole picture? Best seen in the standard and the pleading that has the defendant's response. So firstly, the standard at tab 14 of the supplemental bundle. Page 209.
209.
209, yes. And you see at the top of the page, the rule my lords and my lady need is the one that starts with the first bullet point and then has 3 indented bullet points. See that? So it's about 6 lines long, including the spaces. But it commences, expressly starts, if the transmission contains any scheduled data. And then it explains that the size of the selected MAC EPDU shall not exceed the total of, and then various matters are set out. And we rely upon that rule and plead the effect of this is that the size of the ETFC must not or cannot exceed the size of the data allowed by the serving and non-serving grants. And you see at tab 7 of the supplementary bundle, this is a pleading that has both sides pleading in. So it's formally theirs, but it's got ours because it's done by way of a chart. And the key text is at page 107. You see the entry for integer 1f that sets out some earlier text in the rule that we also rely on, but also the operative part of the rule that we've just seen, the standard in the standard. Selected MAC-E PDU shall not exceed the total of. We need to go over the page. Formatting of this document is that bits of our pleading get knocked down because of them putting more text in the right-hand side. But you go over the page, you see the conclusion that we say the effect of that rule is towards the bottom of 108 in the middle.
That's your interpretation, is it, rather than the words of the standard
Exactly.
itself?
Exactly. That's our allegation of the words of the standard are set out in quotes on the previous page.
Yeah.
And that's why the formatting's gone a bit funny when you see what they've said. It means that what we actually... I imagine that what it said is it was right underneath the last bullet point. It's just been knocked down. But that is our contention as to what the effect of that rule is. That obviously then has to be programmed in to the phone. And the reason I'm showing you it here is because my lady can see the 4 specific points. The way this case progressed was we identified what we were relying upon and what the contentions were, and then the defendant set out the 4 specific points they relied upon as to why it was not essential. And they are all down the right-hand column. And the only one that remains at all relevant is the 4th one added by amendment. So it's the red one on page 109. And it's the argument that when only non-scheduled data is being transmitted, the amount of MAC deflow data is not limited to the next smaller ETFC. So that's the argument that the claim requires it every time, and that doing it every time is missing. No other relevant point was raised. And while we have it open, Claim 5 is addressed in the pleading, but consistent with both parties' positions before this court, and in fact, before the judge, you go forward to 115. The integers are set out, both our position and the contention back from the defendant is just see integer 1 above. So you go through 115, 116. The entries are the same. It's not common ground that my pleading's wrong at all. We identified the words in the standard we relied upon. Of course, they didn't cover the special case where only non-scheduled data is being sent. Lenovo identified that in their non-infringement point, and that's the only point so far as relevant, saying that it didn't do it then, and in effect setting up the argument that the claim required it, and therefore, and it was missing, so there was no essentiality. We and the judge dealt with the case on infringement in the light of the positive points put up by Lenovo. Now that's enough in my submission to deal with the point, but it's in fact worse for my friend because Dr. Irvine sought to show non-infringement by reference to the algorithm at Annex C of the standard, which in fact proved the opposite. Now my friend seeks to say any implementation need not be precisely in that form. What he fails to mention is his expert put it in and explained that any actual implementation would have to produce an equivalent output. Can I show you that? The supplementary bundle, tab 10, page 139. Paragraph 9.33, where he's explaining the Annex C implementation in the standard. Look what he says in the last 3 or 4 lines. Any actual implementation will produce an equivalent output to the algorithm in Annex C. And we could see that infringement is established, although the judge didn't have to deal with this because there were only those positive non-infringement points. It was established. And you can see that from the cross-examination extract that we included in our closing. If you go to tab 18, actually before you do that, just put your finger in tab 10 and at 145, just note that he sets out the diagram Annex C with boxes labelled with numbers, and you're going to see a reference to box 18, so it's down towards the bottom on the right hand side, just slightly to the right above the bottom diamond. You see it? So that's what, when you see in a minute box 18, this is what we're talking about. So tab 18 is where I want to take my lords and my lady. This is an extract from our closing. Pick it up at page 277. You see the text of the rule in the standard set out at para 202, what I showed you in the standard right at the outset of this little section. And over the page we see an extract at para 205, me asking Dr. Irvine about this. As I said, it's reference back to that earlier diagram and the box labelled 18. And the key point in this extract is line 5, identifying the difference between the data allowed by scheduled and non-scheduled grants and the next smaller ETFC. You see he agrees with that, the answer at line 8. He confirms the next smaller is the largest that's smaller, i.e. the words of the claim. And he agrees that the loss of capacity, i.e. the reduction that you're imposing, which we've just seen is calculated using the size of the next smaller ETFC, is the loss of capacity that one suffers by restricting the payload to the next smallest ETFC. That's what it does. If one uses the size of the next smaller ETFC to calculate a loss of capacity, and that's taken off the available capacity, exactly applying the next smaller ETFC as a limit. You see that over the top of the next page. Lines 8 to 11 of the transcript. He agrees that the two operations, that's calculating the loss and then subtracting from the available payload, are means to limit the data multiplexed into the MAC ePDU to the ETFC size that's next smaller to that allowed by the grant. He agrees. And of course, remember, this is Dr. Irvine who understood the claim in the same way as I advance before my lords and my lady. Not getting into how the overall available payload may be adjusted after it's reduced between the different categories. It's not getting into a specific method, of course not, but nor does the claim. What it is doing is applying that size of the ETFC as a limit, as we see. That's all I wanted to say about infringement. Final issue I need to cover is the argument we saw front and centre of my friend's skeleton that my Lord Justice Arnold asked me about earlier. And I was going to be brief on this. this is the means for in the claim is to be construed as simply means suitable for. My submission is it's quite an extraordinary submission. And in terms of new arguments raised on the appeal, this is where one finds the novelty. First thing to note, something that I've already said, it's completely contrary to his assertion that the claim scope is equivalent to the method claim. Second thing, related, if right, in this case it must surely apply to all three means for integers. So none of the steps in the procedure, in fact, have to be carried out in the apparatus of Claim 1. They just have to be suitable, making the apparatus claim bear no resemblance to the method at all. Third, a point that I foreshadowed as well, the submission is inconsistent with my friend's primary case. Primary case that the correct construction is Lenovo's construction. That construction does require the limit to actually be applied. Just it requires even more, as we've discussed, no TTI when any mobile may opt out. How, we ask, is this submission remotely consistent with the argument that Lenovo's construction is the right one? Fourth, the argument is focused on the well-known effect of cases which are concerned with the introductory words of product claims. So, for example, the seating system for an aircraft in the Virgin case. It doesn't have to be a seating system already installed in an aircraft. It has to be suitable to be installed and used in an aircraft. But that's not the same point as language not in the introductory words of the claim, but applied to integers that are describing the steps in a procedure that the apparatus is clearly intended to operate by. Now, we've given, my lords and my lady, chapter and verse on this argument in the annex to our reply, including pointing out it depends upon a rather selective reading of the guidance. For instance, ignoring that the guidance that he relies upon says it's concerned with claims that commence with words such as apparatus for, and cutting short the reference that he relies upon before the exception to computer-controlled apparatus is mentioned, which is dead against him. I don't propose to say any more at this stage because I rather doubt that it can really form a plank in my friend's case, certainly can't to support his own construction. And as I said to my Lord Justice Arnold before, it doesn't even support the judge's construction, because the judge was construing the claim as requiring means adapted to achieve a particular result. He just was focused on the wrong thing as a result, and he certainly wasn't saying it never has to achieve whatever the result is he had in mind, which is what this submission is. I've got to the end of my note. Is there anything else that I can assist you in?
There's one detailed procedural point, which probably is a question for Mr. Abrams rather than you, but I will ask it anyway. In Mr. Abrams' skeleton argument, paragraph 51, he says that Lord Justice Burse adjourned the question of whether you should be allowed to rely on Claim 5 to the hearing of the appeal. Well, I couldn't see that in Lord Justice Burse's order or in the very short judgment that he gave.
Right. It definitely happened because he raised it and said, I can't rely on it, and the judge said he wasn't deciding it. So
it is live.
It's fair that he raised the point at the hearing,
right,
and it wasn't decided in either of our favours.
Right.
I hope that's fair.
Yeah. Thank you. I just couldn't see it in the order.
No, it came in the discussion at the end about the form of. As I hope my recollection is correct. We said, is there going to be something in the order? And he just said, no, you can argue about that in front of the lordships.
Yeah, all right.
Is there anything else I can assist my lady on?
No, thank you very much, Mr. Speck. Yes, Mr. Abrams.
My lord, can I start with identifying what we understand the issues of construction are? Because we don't agree with my learned friend's characterisation, particularly of his characterisation of our position. Now, my learned friend is right that the skeleton arguments identify 3 constructions, but a more structured approach is to consider 2 separate binary issues of construction, and then I'll tell you how they relate to the 3 issues. The 3 constructions. One issue of construction is raised by InterDigital's appeal, and one issue of construction is raised by Lenovo's respondent's notice. So if your lordship has the call bundle, the first issue of construction, which is raised by InterDigital's appeal, concerns paragraph 184 of the judgment. That's page 125 of the bundle. So here, the judge is saying that integer 1f is satisfied by any means which bring about the stated result, which is to say the amount of MAC flow data multiplexed into a MAC EPDU is limited to a largest ETFC size, etc., etc., etc. And it was his finding in paragraph 184, which he then applied in relation to DXX14, which led to ultimately...
Well, that's your submission,
yes.
but Mr. Speck's submission is to the contrary. He says he's quite happy with 184,
yes.
but he disputes that the judge applied that construction at the back end of the judgment.
Indeed. In which case, well, let's come to that. When I say 184, so perhaps with that, when I say paragraph 184, I mean paragraph 184 as it leads to the result in DXX14. I mean, my submission, of course, is we know what the judge meant in 184 because we see him applying 184 in DXX14. So if I may be permitted to say 184, subject to that caveat, my lord, and I will address that caveat head on, of course. But at this stage, I'm just addressing the issues. The judge, no doubt, thought that he was applying that in DXX14, unless he was very forgetful indeed. So, InterDigital say that the judge was wrong, at least to the extent that it had the consequences in DXX14. We entirely agree with paragraph 184 of the judgment. And in our skeleton argument, our first 5 submissions on construction, paragraphs 23 to 28, are directed at that issue, at paragraph 184 of the judgment, and it's saying that that is correct. So let me be absolutely clear, my lords. My primary case in this court is that the judge was right in paragraph 184, and therefore in relation to DXX14, and therefore the appeal should simply be dismissed on the grounds that the judge was right.
What do you understand by the stated result?
The stated result is that the amount of MAC flow data multiplexed into a MAC EPDU is limited to a largest ETFC size, and then I insert the rest of the claim. So
that's not applying a rule requiring it be limited. That's directed to the end, not the process.
Indeed, but it is, and again I'm going to come to this, it is directed at limiting. It is not merely that by happenstance the amount of data that comes out of the other end in fact turns out to be less than a largest ETFC size ... It is actually limiting. Okay? The claim doesn't require a rule, save insofar as the claim requires that the amount of data be limited to a largest ETFC size that is smaller than ... And that, I'm going to show your lordships that that's what the judge was doing in relation to DXX14. So I'm going to hopefully demonstrate to your lordships that that is indeed what the judge meant in 184, because that's how he approached DXX14, and we say he was entirely right to do so. Okay? So the second issue of construction is raised by my respondent's notice, relates to paragraph 183 of the judgment. And this is a finding that it's sufficient for infringement if the device sometimes limits the amount of MAC flow data multiplexed. And so this finding at paragraph 183 means that the claim covers a device in which the limit can be exceeded on some or many or most occasions. And when I say most occasions, I of course mean most TTIs. Now, of course, this isn't necessary for us to win our appeal, but our respondent's notice invites this court to reconsider whether the judge was right in 183, and that's the second construction issue. And some of the arguments bleed into each other, so it would be, in the end, your Lordship's task would be more difficult if you didn't have 183 live, and I'll explain that as well. When we are, in case it matters, we're not asking the court to construe the expression means for in anything other than its conventional sense. That's not where the debate lies.
Well, you say anything other than its conventional sense, but that statement is ambiguous without a definition of what you mean by the conventional sense. Because, as discussed with Mr. Speck, if what you mean by that is suitable for, number one, it's not necessarily correct to say that that's conventional in this context, and number two, that doesn't seem to be how the judge construed it anyway.
No. I was going to go to the EPO guidelines, which to my eyes anyway, make this point clear about adapted and what adapted means. And in this context, what the claim is talking about is an apparatus which is adapted to do 1F. So your Lordship and I think, okay.
Very good, yeah.
It is adapted, and adapted in this context means programmed too. The debate is about the word limiting, and we ask your Lordships to construe the word limiting as really meaning limited. So we say that, I'm just using the words of the claim now, the means are not for limiting, or the means are not adapted to limit, if the limit can be exceeded. So the claim doesn't cover a device in which the limit can be exceeded, we say. And in our skeleton argument, this is the subject of our 6th to 9th submissions, paragraphs 29 to 35. So my learned friend does not accurately describe my position in his skeleton argument in his oral submissions, because he suggested that we were with him on what I call the first issue, and the only point of difference was the second issue. The position is, the three constructions are in fact these. Firstly, the judge obviously says, the judge's construction is that the judge was right in 183 and 184. Our construction is the judge was right in 184, with the knock-on effect that he was right in relation to DXX 14, but we respectfully differ from the judge in relation to 183. And InterDigital say the judge was right in 183 and wrong in relation to 184 stroke DXX 14. So I'll be addressing your Lordship on those two issues of construction, 184 and 183. Now, before I come to my submissions on those two issues, I need to explain two aspects about the course of the proceedings below, which will help your Lordships to put some of the arguments into context, and in particular, to put into context the island hopping that my learned friend did in respect of some of the evidence, if your Lordship will permit me to adopt that phrase, that happy phrase. And there are two bits of the proceedings which I need to explain to your Lordships, which I'm not confident that your Lordship's got fully on board. The first point I need to make is that your Lordship need to have always in mind that the main issue at trial, which occupied by far the most time and attention, was the dispute over what the filial prior art disclosed. And in that context, we had detailed poring over the text and hours, if not days, of cross-examination over the experts over what exactly it meant, and also in relation to the common general knowledge that bore on that issue of what the document meant. And your Lordship has saved all of that, and your Lordship. The judge said that Mr. Townend's description was right, and in this court, that's the basis on which we're proceeding. And so I'll be using Mr. Townend's summary of filial as the explanation of filial because it's much easier than actually going to the text. But the key point about this, the two key points are, firstly, that amount of time and effort, so everyone's attention is always focused on that. And secondly, our case on filial was that it actually disclosed what I call the detailed process that InterDigital now seeks to write into the Claim 1. Okay? If your lordships want a reference for that, in Irvin 2, which is in the supplemental bundle at page 167, at paragraph 4.9, he said that the right-hand side of X3, we're showing X3, he said expressly that that right-hand side represented his understanding of what filia trial did. So he was saying that's how filia trial worked. Okay? And that was my case, which I sweated blood and tears over and was ultimately unsuccessful. So when we look, and your lordship and your ladyship know what's coming now. If we can go to the judgment, paragraph 199, let's say, on page 128. My learned friend showed you paragraph 199C. Third, does filia trial disclose the additional selection step, i.e. step 2 on the right-hand side of X3? He's right. That was the question that he had to ask himself. But not because Claim 1 actually requires step 2, or that that's the only way to get within Claim 1. It was because my case and my evidence, what Dr. Irvin had said in particular, was that filia trial actually disclosed step 2. It disclosed the whole of the right-hand side of the picture at the bottom of 127. And that's why that was a question. And while I'm on page 128, at the top, my learned friend drew attention to the judge using the phrase...
Sorry, can you explain to me, why would you have spent a lot of time, effort and money, and why would the judge have sweated so much over the judgment to answer a question that didn't need to be answered?
Oh, it did need to... Do you mean because the XX14 was resolved it, or because the claim was brought? Oh, I know, you don't mean that.
If you say it's not necessary to establish to get within Claim 1, why bother?
Because,
why make such a fight over it?
Because the dispute on filia trial was binary. Is it the left-hand side, if your lordship's got the bottom of 127, is it the left-hand side or the right-hand side? Mr. Townend and InterDigital was saying Lenovo was specific, it taught the left-hand side, and Mr. Irvine and me and Lenovo were saying filia trial taught the right-hand side. I mean, filia trial was very, very detailed. It's not a general document. And so there was a binary question for the judge. Is it the left or is it the right? So if it wasn't the right, there was no other way I could bring filia trial within the claim unless it taught on the right-hand side.
But that includes the selection step, which you're now saying you didn't need to establish.
Well, I did if to establish that filia trial, to establish my primary case on filia trial, I needed to establish that filia trial disclosed that step, because if it didn't, if I was wrong about that, then filia trial was disclosing the left-hand side. Of course, just to be clear about that, I wasn't saying specifically filia trial discloses step 2. I was saying filia trial discloses a procedure 1, 2, 3, 3A4. That was my case. And in the case I was faced with was no, filia trial discloses a completely different set of steps, 1, 2, 3, 4 on the left-hand side. And that was the binary question that the judge had to answer.
But I don't understand this. I'm sorry to keep on asking you questions, because in 195B, the judge says in terms that the patent scheme requires step 2.
Yeah.
And that's why it was essential from the judge's perspective to resolve the issue between the parties,
Yeah.
because he went directly to what he perceived to be a requirement of the claim.
Okay. So when we say the patent scheme, it's undoubtedly the case that the patent discloses a number of schemes, including a scheme that includes step 2. I'm talking about the general disclosure. And it may well be that the judge was carefully using the phrase the patent scheme rather than the scheme of Claim 1, because he was not wanting to get into that particular debate at that particular time. So his language is not, this is the claim scheme. There is no question that the patent in the general disclosure discloses a scheme of that has step 2 in it. In any case, more broadly, this language is like all of this section. is not directed to the point that we're now debating about the precise contours of the claim for this purpose. This was simply directing attention to the binary question: is Dr. Irvin right that Filitrao works as per the right-hand side of this diagram?
Again, I'm a bit puzzled. Are you making some kind of point about the difference between Claim 1 and Claim 2? That can't matter.
No.
And at 152, the judge says, and I don't understand this to be in dispute, that the ETFC selection step is introduced in Claim 2.
Yes.
So you may be right to say that in 195B he's not focusing on Claim 1 as distinct from Claim 2, but why would that matter?
No, that's not my point. My point is he's focusing on two things. He's focusing primarily on this binary debate about whether Filitrao discloses the left-hand side and the right-hand side. And when he says the patent scheme, I would suggest that he's talking about the patent at a higher level in relation to the embodiments and the invention described generally, and not at this stage outlining the contours of Claim 1 as regard, or Claim 2 for that matter, as regards this particular debate. It's just not an issue at this stage whether Claim 1 requires Step 2. And this is going to make.
So, what about Claim 2? Do you make the same submission in relation to Claim 2?
Well, no one suggests Claim 2 requires that Step 2. No one suggests that Step 2 is a requirement of Claim 2.
Isn't that? Why isn't that
No.
what the judge is saying at 152?
No.
I might be able to assist. What the judge is talking about is what's the step 3 on the left-hand side and 3A on the right-hand side.
Right.
Which is the separate selection as to what you actually use once you've multiplexed it.
Thank you. I'm grateful.
And as my Lord Justice Lewison pointed out, just for completeness, when the judge said at 301, for all these reasons I reject all of the various ways in Lenovo, argued that Filitrao anticipated. Obviously, he meant all of the ways up to now. And again, that re-emphasises that everyone's primary focus was on the primary case, that Filitrao actually disclosed what we see on the right-hand side of X3. He obviously then went on to consider the final point that he mentioned, that he identified back at paragraph 150, excuse me, where he summarised the 4 ways that we put our case. So, just going back to paragraph 184, we say it really is an impossible submission for my learned friend to say that the judge adopted a different construction in relation to DXX14 and my primary case on Filitrao. As you see from page 125 of the bundle, at 184 he says that integer 1f is expressed in very broad terms. He then considers the primary case on Filitrao, and you're right, and your lordship's are obviously right, that if one takes, for example, paragraph 199C out of context, one looks as though he's treating the claim as being much narrower. And the idea has to be that he then, having finished that section at paragraph 314, when he considers whether we can get home on obviousness, he then forgets that construction at 315 and forgets that he believes that claim 1 requires, in particular, step 2. It's just simply impossible that the judge could have forgotten a construction adopted by him that claim 1 requires step 2. When he comes on to consider DXX14, it's quite clear from his decision on DXX14 that he is not saying that claim 1 is limited to step 2, that he is saying that I need to answer the question whether Filitrao discloses.
To be sure, but the submission is not that he forgot his own construction, nor is the submission that he had was consciously applying a different construction. The submission is the judge may have thought he was applying the same construction, but on analysis he didn't.
Well, as I say, that's I've given you, Lordships, the answer. He's consistent throughout. 184 says it's very broad, and when he deals with DXX14, he deals with it broadly, although not as broadly as my learned friend would suggest, as I'll demonstrate in a moment. And so, given those two bookends for the section on filial, the only sensible reading of the parts that we were debating in the section on the primary case on filial is that he was considering the question whether or not filial included step 2, not because he regarded it as a requirement, but because that was what I was offering to prove, and it was only by proving that I could get home on filial. This point is reinforced by the next point I'm going to make about the course of the proceedings below, and that's the development of the infringement case. Now, as your Lordship and your Ladyship know, InterDigital's infringement case was and has always been simply that the patent is essential to the standard. So if it's essential, my clients infringe; if not, not. And the starting point for that is the statement of case on essentiality, which my learned friend showed you that the statement of case on essentiality is in tab 3 of the supplementary bundle. My learned friend showed it to you in a different tab, so it may be more convenient for your Lordships to go back to that.
You want to go to tab 3, though, do you?
Is it tab 7? Yeah, so it's tab. We may as well go to tab 7, because your Lordships already looked at that. I'll just make the point that this document remained unamended throughout. The document we're looking at was my client's responsive pleading, but the pleading which it quoted remained unamended throughout. And the integer in question is integer 1f, which starts on page 107. And as your Lordships saw, the text in italics, it quotes some text from the standard, and then it has, I think your Lordship called it the interpretation or the allegation at the bottom of page 108. Therefore, that's sensible. Now, there are 2 points to make about this. First is that this is just simply saying that the size of the ETFC cannot exceed the size of the MACD flow data allowed by the serving of non-scheduled grants. There's no suggestion here that the standard requires what my learned friend now says should be written into Claim 1. He says that Claim 1 requires that you actually identify the next smaller ETFC and use that as a multiplexing limit. All this says is that the ETFC size cannot exceed the size of the MACD flow data. So what is definitely now his construction is not reflected here. He's not offering to prove that the standard requires that. And so he's obviously not advancing at this stage of construction that anything more is required simply than the size of the ETFC cannot exceed the size of the MACD flow data allowed by the grants. The second point, of course, is the word cannot. That's an unqualified. The ETFC cannot exceed the size of the MACD flow data. And so we say that at this stage, it looks to all the world as though InterDigital are construing the claim in the way that Lenovo now does. One is no particular procedure is required. All that's required is that the ETFC is not bigger than the MACD flow data. It requires nothing more than that. And secondly, cannot. There's no acknowledgement there that this is only true in certain specific cases. I mean, if one understands the text, one can understand that, but that's not acknowledged in the pleading at all. Now, our answer to this pleading, as your Lordships have seen, was that the size of the ETFC can exceed the grants in some circumstances. Of course, we never said the standard doesn't require specifically identifying the next smaller ETFC and using that as a multiplexing limit, because it wasn't alleged that the standard required identifying the next smaller ETFC and using it as a multiplexing limit. That's what my learned friend now says the claim requires, but he wasn't and never has offered to prove that the standard requires that. Now, as I say, the issue as far as we were concerned is whether cannot was true. So our first round evidence, Irving 1, explained in detail how the standard does allow the size of the ETFC to exceed the grants in some circumstances. And InterDigital's first round evidence did not accept this. Indeed, it seemed to be consistent with the pleaded case, by which I mean cannot. So in reply evidence, we put in Irving 2, which expanded on the point yet further. And it was only in reply evidence in Townend 2 that InterDigital finally admitted that we were right about the standard and that cannot is wrong. So when I say in my skeleton it's now common ground that this is wrong, it's common ground that the word cannot is wrong because it can exceed, the ETFC can exceed the size of the MAC flow data allowed by the serving and non-scheduled grants. And then in their opening skeleton, they address this as a matter of construction, saying that they don't need, it's fine that it's not, that cannot is not true. But your lordship and your ladyship will see throughout all of this, nobody was saying that the standard required the mobile to identify the next smaller ETFC and use that specifically as a multiplexing limit. That was never pleaded, and so we just never occurred to anyone on our side that they were saying that that was a requirement of the claim. So it was, as I say, in reply evidence, they identified, they accepted cannot is wrong. And so at that stage, what I call the second issue of construction crystallised. At that stage, it became...
Well, you may want to come to this in due course, but you say it didn't occur to you. But Mr. Speck's submission to us this morning was that actually it did occur to Mr. Worthing because he said it.
Yes. Well, that's the point. That's the point I'm coming to. I mean, one can't take an expert, not a lawyer's, or much less a judge's summary of the claim, written without a particular construction dispute in mind, as being accepting that that's the answer on a particular construction. It's just not fair on the expert, let alone on the party calling the expert, to hold that sort of summary, to say that that sort of summary answers a question which was never in anybody's mind, the expert nor those asking the expert to produce the report. Just if I may pick up the history, so it's after the second round of expert evidence when the InterDigital for the first time are saying that they can win even if the limit can be exceeded on occasion, that we respond by saying, well, if that's okay, if you're allowed to exceed the limit on occasion, then the prior art is within the claim as demonstrated by DXX14, which we served in advance of trial. And that explains why DXX14 came into the case when it did, because up until the reply evidence, InterDigital seemed to be saying the claim required that the ETFC cannot exceed the size, and the battle seemed to be about whether that was true or not as a matter of interpretation of the standard. And both these points I've been making, so that's number one, the main focus was on what Philitro actually disclosed, and number two, that this debate, which is now crystallised in paragraph 183 of the judge's judgment, was not in people's mind, means that it would be quite wrong in my respectful submission for your lordships to place really any significant weight on, for example, how an expert attempted to summarise the claim. Because the expert's just not directing their mind at that stage to that question. So my learned friend's favourite paragraph was, and which I think my lord was referring to a moment ago, is paragraph 8.38 of Irving 1, which does describe the claim in terms that my learned friend likes, but the explanation is simply because he was summarising the claim for a completely different point. He was summarising the claim for the purpose of then going on to explain that the standard doesn't do this, because in the standard it's perfectly possible for the amount of data multiplex to exceed the next smaller ETFC. And that was the debate. I mean, that paragraph is obviously wrong as a summary of the claim, because it doesn't even mention integers 1a to 1f. So it's quite clearly not a correct summary of the claim. So, my lords, that's why your lordships can't take anything from turns of phrase in expert evidence not written with these points we're arguing in mind. Now I'm going to turn to my submissions on the first construction issue, which is, given my lord's question, is really what did the judge decide in 184 and was he right? And for this purpose, the right place to start is DXX14, which is in the core bundle at page 156. Now, what I'm going to do is I'm going to summarise DXX14 before I get into the detail of it. So yes, that's tab 8 of the core bundle, page 156. So DXX14 starts at the top with a quotation from Townend 1, paragraph 305A, which the judge held, and we now all agree, properly summarises part of the process disclosed in Filia Trout. Okay. And then the picture shows part of the process in action in an example scenario. And the result of the process disclosed in Filia Trout is that the UE creates a MAC EPDU, which we see at the end at stage 4. So it multiplexes a header and 3 MAC dflow data blocks together with some padding. Okay. So that's the end result. The multiplexed data is 3 MACD data blocks. Okay. Now for the detail. Now when considering DXX14, the point made by the judge in the last 2 sentences at the end of paragraph 316 is very important.
In the paragraph 316? 316.
Those last 2 sentences are absolutely critical to a proper understanding of these 2 pages of judgment and of DXX14. So he's saying, he's recording Mr. Townend's clarification. The text from paragraph 305A quoted in DXX14, and therefore the process shown in DXX14, contemplates that ETFC restriction has already taken place and that all the illustrated ETFCs are supported. And it's very important that your lordships understand what that means.
But why is that important? Because restriction is not part of the claim.
Well, it is part of the claim, actually, my lord. It's integer 1e.
All right, but it's not not the disputed part of the claim.
No, indeed. Let me explain why it's so important. Okay. Now, ETFC I said a moment ago that everyone agrees that Mr. Townend's summary of Filia Trout is correct. So we can, if your lordships don't mind keeping open the core bundle and going to Mr. Townend's summary in the supplementary bundle at tab 12, page 175. So steps 8, so if you've got 175, paragraph 166, here he's summarising Filia Trout, and steps A to C are summarising the ETFC restriction procedure that takes place before you get to DXX14. And the key thing about that is that at the end of C, you see the phrase you see that the mobile uses the UE as the mobile, the UE's remaining power to determine which ETFCs within the specified ETFC are supported. And just to explain that, my learned friend explained how this patent relates to HSUPA. The way that HSUPA works is that the mobile phone first works out how much power it needs to transmit all its other channels, and then what it's got left over, it can use for HSUPA. And so, in this stage, the mobile determines which ETFCs it can use, which it's got enough power remaining to use. And that's expressed more pithily in integer 1e of the claim. So, for your lordships, you can just flick back to page 120 of the core bundle. And see integer 1e means for determining a supported ETFCs within an ETFC set based on remaining transmit power for the enhanced uplink. So if I can go back to 156. So yes, and of course it's common ground that integer 1e is disclosed in Filitrao. So what Mr. Townend describes in his 166 ABC satisfies integer 1e. That's all common ground. Now, if we go back to page 156, as the judge of the core bundle, I do apologise, the core bundle.
We finished with Mr. Townend?
No, not yet. Sorry, no.
Right.
Sorry. There's one more thing in Mr. Townend.
Right. 156.
156. As the judge says in 316, ETFC restriction has taken place, and all, and this is really crucial, all the illustrated TFCs are supported, okay, including ETFC 5. Now, the significance of this is that at this stage, so after ETFC restriction, before we get to DXX14, there's nothing to stop the mobile sending as much data as ETFC 5 will carry. Okay? You can see from the size of the MACD blocks that ETFC 5 could accommodate 4 of those blocks. Yeah? And the reason I wanted your lordship to keep Mr. Townend opened was that he makes the point specifically in D that the mobile should maximise the amount of highest priority data to be transmitted. So the mobile will never send 3 blocks if it can send 4, and it never send 4 if it can send 5. Okay? So that's why I'm stressing that at the start of DXX14, after ETFC restriction process, there's absolutely nothing so far to stop the UE from multiplexing 4 MACD flow data blocks. However, then comes this process illustrated in DXX14, which Mr. Townend describes in his 305A. And the effect of that process is to limit the amount of MACD flow data to be within ETFC 4, i.e. the largest ETFC size that is smaller than the grants. And that was confirmed by Mr. Townend in the cross-examination quoted by the judge. Now, and then the judge accepts that as a matter of fact in 318. And what's crucial is that Mr. Townend and the judge both have well in mind that ETFC restriction has just taken place. So the cross-examination here, just for, if you want to write by the side of it, I won't go to it, it's in the supplemental bundle, the transcript is in the supplemental bundle tab 16219. We discussed ETFC restriction immediately before this bit of cross-examination which is noted. And the judge didn't set out that cross-examination, he just summarised its effect at the end of 316. Both the judge and Mr. Townend have got in mind that ETFC 5 is supported, and therefore, in the process so far, there's nothing to stop the mobile from sending 4 MACD blocks. And that's why Mr. Townend agreed with me at the question at the end of 317, not merely that the UE will end up sending 3 MACD data blocks, that the UE would limit the amount of MACD flow data to be within the large DTFC size that's smaller than the grant. Because what's being shown here is a process of limiting. It's not merely a process of working out how many to send. Should I send 2? Should I send 3? Should I send 4? It's limiting the amount of data which the mobile could otherwise send. Because if it wasn't for this process, the UE would be using ETFC5.
How is it doing that?
How is it?
How is it doing?
limiting?
How is it limiting it?
Yes, it's limiting it because, well, in the way summarised in at the top of DXX 14, Mr. Townend's paragraph 305A. It uses the
by
graph-
selecting the ETFC.
It uses the well. It's I mean I wouldn't want to paraphrase paragraph 305A. Filatrao uses the grants as a multiplexing limit in a MACD-PADU and then selects the smallest ETFC, which is larger than the multiplex data. And the point is that in this scenario, what the UE is doing is actually limiting the amount of MACD flow data as required by integer 1F. And that's, my lord, I've endeavoured to explain why the last 2 sentences of paragraph 316 are so crucial, because the last 2 sentences of 316 you can read as saying, before we get here, the mobile is able to send 4 or more MACD flow blocks. Able to multiplex 4 or more.
Could you just help me
Yes.
on this, Mr. Abrams? I think I understand the point you're making, but to assist me, could you point me to the passage in your skeleton argument where you identify the crucial importance of those 2 sentences to your case?
It may well be that I don't, because, and the reason...
Well,
reason,
I'm not surprised to hear you say that, because I was just looking for it. I couldn't see it mentioned anywhere.
No, and the reason is because we all get so familiar with ETFC restriction. We know that this is after ETFC restriction, and we've all got in mind you do ETFC restriction first, and the judge says it, and it only twigged me later that you, listening to my learned friend, reinforced it, that your lordships might not realise that this is actually a process of limiting. I mean, as I say, my skeleton made the point that the witness and the judge both referred to this as limiting, and the way my learned friend described it didn't make clear that this is actually a process of limiting. I mean, it follows from the description of ETFC restriction. I mean, the judge explained ETFC restriction earlier in his judgment. As my Lord Justice Lewison said, there is a lot of jargon in this case, and the judge, being familiar with this area of technology, did use some of those jargon.
Can I just ask you another question, which I'm not sure that I don't quite follow what's being said in this quoted paragraph from Townend. In the second sentence, quoted at the top of page 156, he says, this allows the selected ETFC to be larger than the sum of the grants. But if I've understood the diagram, the sum of the grants is the dotted red line, and the selected ETFC is smaller.
Yes.
So how is it larger?
No, it's not. What he means is, in other scenarios, it could be larger. So allows is the key word.
Oh, I see.
So we included the first sentence of that is how Filatrao works. The second sentence is his comment, and we included it because we didn't want to be accused of partial quotation. The second sentence is not a description of how Filatrao works. It's his comment on what could happen in some circumstances in Filatrao. Neither of those possibilities are occurring in this scenario.
Does my lord understand the diagrams were not provided by Townend? What's happened in all of these is that my friend's side has taken a quote and then tried to illustrate.
Right. He's right, of course, but of course Mr. Townend agreed that this is how Filatrao works. He absolutely agreed that this is how Filatrao works in this particular scenario, according to him, and therefore according to the judge, and according to everyone in this court now. Yep. So there's no difficulty with that. And so, In paragraph 318 of the judgment, when the judge says, Mr. Town accepted with certain particular MAC PDU sizes and particular grants associated with DX14, Filitrial had means which produced the result required by integer 1f of the patent. That's not merely the result in the sense of you get out the other end a MAC DPDU which looks like the MAC EPDU you would get from the patent. It's the result in the sense that the amount of data is actually limited as integer 1f requires. And so, listening to my learned friend, you might think that it was my case that I was saying all integer 1f requires is that what comes out the other end is a MAC EPDU, which looks like the MAC EPDU that would come out if you followed the claim in another way. But it's more than that. It's that, Filitrial discloses more than that. Filitrial discloses a system in which the mobile does actually limit, imposes a limit, and it is the limit of 1f. And in that context, it's important. The other point that my learned friend makes is to try and give the flavour that this is an exceptional situation. Of course, the judge addressed that specifically at paragraph 321. No suggestion that this is de minimis. So it's no answer to that and no criticism to this case that this is an exceptional or unusual situation. That's just not the findings of the judge or the facts. So what follows from this is, exactly as the judge said, that a mobile phone that's built in accordance with Filitrial, following the instructions in Filitrial, must have means which are adapted to, which are programmed to, and capable of, and suitable for, they're all of those things. They're adapted to limit the amount of data as per integer 1f. When I say as per integer 1f, I use that as a shorthand for those long words. The mobile must be adapted, i.e. programmed, to do that, at least in some scenarios. And if one considers this from the point of view of integer 5f, Filitrial discloses a method, and the method includes all of the steps in 5a to 5f. In relation to 5f, 5f is a step of limiting the amount of data to ... And what we see from this diagram is that Filitrial discloses a method which does actually limit the amount of data as per integer 5f. Not merely a method which produces the same output, but a method which does actually do limiting, and it does the limiting required by integer 5f. And so we say, that now your lordships understand, I hope, why we say that the judge in 184 was saying that the claim covers any means which bring about the stated result being limiting as per integer 1f or 5f. And we say it's an impossible submission for my own friend to say that the judge could have written these 2 pages if he had previously thought that claim 1 was narrower, and that's my submission on taking words out of context in the section that was dealing with the primary issue on disclosure of Filitrial. It's now clear, I would respectfully submit, that I'm right, that in that section he was focusing on, is Mr. Abrahams right when he says that Filitrial discloses this? And then in this section he was then considering the full width of claim 1. The only way to escape DXX14, my learned friend, is to write in the words which he says should be written into claim 1, and those are the words in paragraph 48 of his skeleton argument, which I thought at one stage he was agreeing. I'd characterised his position correctly. Paragraph 48 of his skeleton argument, he says that the claim requires specifically selecting that next smaller ETFC and moreover using its size as a limit to multiplexity of data. And the first issue of construction we characterise as, is it right to write those words into integer 1f? And our first submission, obviously, is those words just aren't in integer 1f. Integer 1f is very, very clear indeed. It just simply says limiting, means for limiting. It doesn't say, it doesn't require actually specifically selecting the next smaller ETFC, and it doesn't require using its size as a limit to multiplexity of data. So my submissions on this first issue of construction, so my Lord's supplemental fund, I should have said that earlier.
Sorry, where are we going, Mr.
So my skeleton argument and
Your skeleton.
my skeleton argument, which is in the core bundle tab 4, page 50. And as I said, the first 5 submissions, paragraphs 23 to 28, are directed to this question, whether the judge was right in what we say he said in 184, and or alternatively, whether my learned friend is right that you should write in the words into the claim requiring the mobile to specifically select the next smaller ETFC and use that as a limit on multiplexing. And our first point is obviously, no, it doesn't, because it doesn't say that. All it says is that there are means for limiting the amount of data to a certain amount, and I've shown you how DXX14 does that. At the risk of meticulous verbal analysis, we do draw your Lordship's attention to the fact that integer 1f uses the words multiplexed, so that's referring to the past tense. It's not saying anything about setting a multiplexing limit in advance. It's saying limiting the amount of data that is in fact multiplexed. And now is a convenient point as any to, I promise your Lordship I would go to the EPO guidelines. This is not the core of the dispute, but my learned friend referred to, in the context of the debate on means for, he referred to my omitting from my skeleton argument an important part of the quotation from the EPO guidelines on claims, which is in the authorities bundle at tab 10. So this is a convention for the drafting of European patents, and it's a convention which the skilled reader of the patent would know about. And so 4.13 talks about interpretations of expressions such as apparatus for and product for. And it starts off by saying it's construed as meaning merely apparatus suitable for carrying out the process. And the important point, the point that they're making on this page, is the point at the end of the second paragraph. If the known product is in a form which is in fact suitable for the stated use.
I'm sorry, I'm not on the right page.
Sorry,
332?
Yeah, sorry, I'm on page 330.
Thank you.
I'm sorry. So this is the guidelines used in the European Patent Office. This being European patent, so of course was applied for through that office.
Yes.
And therefore these conventions were applied. And
I'm sorry, and you were on 330 at
330.
the second paragraph.
Well, the first paragraph is the point that they're making, which speaks for itself. And then the emphasis is the last sentence of the second paragraph. So no one is suggesting that it's an answer to the case. So no one is suggesting that my learned friend gets any help from the fact that filial doesn't ever point out that it works in this particular way, if that's in fact how it works. Then over the page on 331, it talks about what they call what the jargon calls means plus function features, brackets mean, quote, means for. And it's effectively the same point. In the second paragraph, they give the example that means for opening a door is anticipated by both a door and a crowbar, and probably by a tank as well.
But then they give the exception, and I understood you
Yes.
earlier to accept
No, absolutely accept
here
that.
within the exception.
Yes. So the exception is, in the case of it relates to computers, because if you take a computer, and in one sense, a computer is suitable for doing all sorts of things because it can easily be programmed to do that. And the exception that they're referring to at the end of page 332, the penultimate paragraph, is in the case of a computer type invention, the computer has to be adapted for doing it, i.e. has to be programmed for doing it. So for example, let's take this computer here. In one sense, this computer is suitable for displaying a picture of your lordships, because if I emailed a picture of your lordships to this computer and pressed the buttons, it would appear. But it hasn't been adapted for that, it's not programmed for that, and it would be too broad to assume that construe it that way. However, if I did load up a picture of your lordships into the computer and displayed it, then it would be suitable for displaying a picture of your lordships. If all that was required, for example, was to plug it in, then it would be. And that's what, having said it out loud, I don't think that's the best example. But the point is that a computer is not suitable for doing something unless it's actually programmed to do that thing. But that doesn't help my learned friend or harm me in any way, because as I've demonstrated, Filatrao contains instructions to program the mobile phone to do those steps that Mr. Townend explained in his paragraph 166 and his 305A. So the computer is adapted to do those things, and those things do result in the amount of data being multiplexed being limited as required by 1F. So that's not an objection.
Yeah.
But the beginning and end of the first point and the beginning and end of this point really is that the words that my learned friend wants to write into this claim, which he set out in his paragraph 48, it is not in the claim. The second submission and the third submission relate to standards. Now, of course, when I talk about the standards here, I'm not talking about the standard as it subsequently appeared after the patent. Obviously, no one's going to construe the patent by reference to standard published afterwards. The point here is that HSUPA was, as my friend said, an enhancement to the UMTS standard. So the UMTS standard already existed as a standard, and people were walking around with 3G mobile phones in their pocket. And this patent is directed at an add-on to that. And our second submission on construction is that the mobile phone standards generally, including the UMTS standard, they generally specify results to be achieved, i.e. what the mobile phone is and is not allowed to transmit. And in relation to integer 1F, it specifies the amount of MACD flow data that the mobile phone is allowed to transmit. The standard doesn't specify matters of implementation. It doesn't specify the internal procedures of the mobile devices. So a skilled reader who is the skilled person in this case, is a person who knows all about standardization. They'd well understand this, and they'd well understand that a patentee would want to claim their invention at the level of the result, what goes over the air, rather than internal procedures. And the third point effectively is the same point from the other end of the other side of the coin, if you like. The patentee could perfectly well have written in the words that my learned friend wants to write into this claim, but no doubt chose not to do so because a claim that was directed at internal procedures to a mobile phone just simply wouldn't be commercially valuable.
I think in answer to a question from me, Mr. Speck said that it was not legitimate to take into account standard when interpreting the patent.
Well, it's certainly
Can
not.
you take issue with that?
It's certainly not legitimate to take into account a subsequent standard.
Oh, I thought, oh, of course. Of course, it's got to
But
be.
it's perfectly. This patent has to be read through the eyes of the skilled person. The skilled person knows full well that standards operate at the level of what's sent between phone and base station and between other elements of the network. And it's perfectly legitimate for the skilled person to say, well, I perfectly understand why this patent is drafted at that level.
Well, that's a very general submission. These standards are incredibly detailed. They extend for hundreds of pages. So I don't think we can simply say, well, it's only about what goes between the phone and the base station, because what goes between the phone and the base station is regulated by, first of all, what goes on within the phone and by what goes on within the base station and what goes on within the RNC and what goes on within the core network and so on.
Indeed. Well, let's focus on then the right thing to do, my lord, is to focus on this particular patent, which is the subject of our fourth submission. And that is, what is this particular patent directed at? And as we all agree, it is directed at what goes over the air. My learned friend started by telling your lordship that this is all about efficient use of what he called the radio resource. The radio resource is, one can think of the imaginary pipeline between all the mobile phones in a cell and the base station controlling that cell. And as he explained very eloquently, from the point of view of any one mobile phone, all the other mobile phones are creating noise and risking drowning out their signals. And that's why all of what they send has to be very tightly controlled. And the point of the patent is not so much to reduce what everybody else is sending, but to make sure that as much as possible of what is sent over the air is not padding. So the entire patent is focused on this imaginary pipeline, which we call the air interface, or the radio interface, or the radio resource. And so it would be quite odd to construe the claim as being directed at and requiring some particular procedure within the mobile phone. What the claim is directed at, and the invention is directed at, is ensuring that this pipeline has as little padding as possible. And what my learned friend seeks to do is to write in to the claim a particular way of constructing the Mac EPDU that has no effect on the amount of padding that it actually contains, in the sense that it doesn't matter whether you do it that particular way or some other way. What matters is whether or not it has the lower amount of padding.
I had in mind a slightly different point, which is to wonder whether one would construe a patent like this on the basis that the patentee meant it to work with the standard and not clash with the standard.
Well, the problem with that is that the standard wasn't written at the date. I mean, my lord, let's be completely frank about what's going on. I'm going to deal with this in a minute, but let's be completely frank, because I think this is where your question is going. What happened here is that the patentee came up with a scheme whereby you use the next smaller ETFC, and it tried to persuade the standard to adopt it. And if the standard had adopted that, it would have been great, and it would have had an essential patent, and it could have got royalties from everyone. But the standard didn't go down that route. They did not have a rule that you use the next smaller ETFC. They had a rule that they had a more complex set of rules. Sometimes you did, sometimes you didn't. So the patentee has had to draft their claim broadly in an attempt to catch the standard. They'd have just limited if the claim had covered what was disclosed in the patent, they'd claimed any of those embodiments, then their claim would have been useless. So as a matter of reality, that's what's happened in this case. They have drafted their claim broadly in an attempt to try and catch the standard. And in doing so, they've also caught the prior art. And then that happens because the system of the standard is not disclosed in the patent. The much more sophisticated system that's in the standard is not disclosed in the patent. In the patent, you always use the next smaller ETFC. And so this is perhaps a jury point, but your lordship should have no sympathy with them because they did not get their invention adopted into the standard, and they've drafted an overbroad claim in an attempt to catch the standard and to be able to extract royalties from people like my clients and everybody else who makes mobile phones and ultimately people who pay for mobile phones. That's the reality of what's happened. So none of that is a legitimate approach to construction of the patent, because of course I'm referring to what's happened subsequently. But it explains what's actually happened in this case, and it explains why the claim has ended up being drafted in such a broad way that it covers the prior art. Now, there is actually a way of avoiding that result, which is to construe the patent to cover what's actually disclosed in the prior art, which is always using the next smaller ETFC. And that's the second construction issue. So your lordships may decide, actually, what the patentee invented was always using the next smaller ETFC. And we should construe the claim to cover that. And that's the second issue of construction. And that avoids the patent reading onto the prior art, the claim reading onto the prior art. I've gone out of my way. We come in this court and we argue about the words of the claim in a sort of abstract, as though these words have sort of fallen from on high. But the reality is that a patent that wasn't adopted for the standard has been massaged to try and make it read onto the standard. My lord, my fifth submission on the first issue of construction is paragraph 28, which is just simply to draw your attention to the fact that there are all sorts of different methods of doing various things in the patent, and the claim language is incredibly broad. It's obviously intended to cover to be as wide as possible, and it should be construed that way. That's paragraph 28 of our skeleton. My lord, I foreshadowed it a moment ago, but I just want to now address head on my learned friend's complaint that the judge's construction covers the prior art. Okay? And there are a number of answers to that complaint. The first point is that the words of the claim are very clear in this respect, and one simply cannot use an argument of this sort to write words into the claim that simply aren't there, and that's what my learned friend is trying to do in this case. The second point is, as I've said, they made a deliberate decision to draft their claim at this level of generality, and that's why they've run into this problem, and I've explained why the real truth of what's going on here. The final point on this is this. To the extent that such a point has any force as an argument of construction, the solution, the right way to distinguish the prior art, if your lordships think it's important to distinguish the prior art, is to adopt Lenovo's construction on the second issue, the point relating to paragraph 183. We say, on the second issue, that claim 1 should be construed as a rule. We say in our skeleton argument a general rule. Perhaps a better word would be a universal rule, or just simply a rule that always applies, that the amount of data is limited as per integer 1f. And as I'm going to explain, not only does that distinguish the prior art, because of course Philitrau did not always limit in that way, it only did so in certain scenarios, it also achieves the benefit of the invention, unlike InterDigital's construction. As I'm going to come to quite soon, InterDigital's construction in relation to both aspects of the claim means that their claim reads onto systems which have nothing to do with the invention, get no benefit from the invention, and are in fact much worse than the prior art in every respect. Whereas if you say that claim 1 and claim 5 are limited to systems in which the amount of data multiplex is always limited to the next smaller ETFC, then the claim covers and only covers all systems which take advantage of the invention. So it covers all systems which take advantage of the invention, and it doesn't cover any which don't.
Well, what about systems which sometimes do and sometimes don't?
Yeah, well, I'm going to come to that in the context of when he deals with that. The short answer is to that is that that's my learned friend giving evidence on his feet. There's no evidence that a skilled person would think of the idea that sometimes they would want an exception reading the patent. The patent doesn't admit of any exceptions. It doesn't contemplate that. There's no hint that this would not be a universal rule. And there's nothing else to make the reader think, oh, well, I would like that. As things have turned out, the standards people decided that they didn't want this universal rule. I mean, they didn't decide, let's be clear, they didn't decide, oh, this is a great rule, but hang on, we need these one or two exceptions. I mean, it's much more sophisticated than that. But there's simply no basis for saying that the skilled reader would want to have an exception. And don't forget, of course, when my learned friend talks about exception, one's thinking about, he gave the example of 5 out of 495. Of course, as your lordship has picked up from my skeleton argument, his construction covers systems in which this is done one time in 100 or more. Okay, so one can't just say, oh, come on, 1% of the time exception is good enough, because if you accept his construction, then you are saying that the
construction is indifferent to whether it's 1% or 99%.
No, indeed, no, that is my point. That is absolutely my point. But what you can't do is say, oh well, the skilled person would want to allow for a small exception. You either have to say the skilled person would accept that this patent covers, this claim covers being used one time.
Well, but I mean, the problem with this argument, and it's a problem on both sides, is you just go round in circles, because you could say, well, the patentee might have wanted to allow for exceptions, such as where the invention is being used 99% of the time, and you riposte, well, he can't have intended that it only be used 1% of the time, but on neither side's interpretation do you discriminate between those. It's all or nothing on both sides.
It is. That's my point, if I may embrace that. It is all or nothing on both sides. But if you construe it, I don't know whether I'm all or nothing. I think I'm. If you construe it as always applying, then the claim is covering what is disclosed in the patent, the invention that is disclosed, and it is limited to systems which always have the benefit that my learned friend explained to your lordship so eloquently. Whereas if it's nothing, or it's not 1.01% of the time, then you are covering systems which owe nothing to the invention and get no benefit from it. I'm going to develop that in a moment. But I embrace that terminology. What I was going to turn to are my submissions on this particular point in my skeleton argument, many of which I've addressed, and the second of which develops the point that I've just been discussed with my lordship. So I'm on page 52 of our skeleton argument in the core bundle.
So you're on
page 52.
52, yes.
And the heading is the judge's construction and Lenovo's construction are both reasonable as a matter of language. But what all of the 6th, 7th, 8th, 9th submissions are going to is this point that what I call the second construction issue, the judgment, paragraph 183, that the claim is better construed as a universal rule. And the first point we make, paragraph 29, is simply that the language is consistent with both approaches to construction on this issue. It is certainly possible, contextually, to read limiting in integer 1f as limiting on a particular occasion, i.e. limiting in one TTI. And it's certainly possible to read it as limiting as a general rule, or perhaps as a universal rule, is the phrase I prefer. And indeed, I've shown your lordship that when InterDigital first pleaded their case, they used the phrase cannot, because they were taking on the burden of showing that the limit could never be exceeded. It was a universal rule. So at that stage, the author of the pleading obviously had in mind that this was a universal rule because they wrote the word cannot. Obviously, they've resolved from that since, but I show you that just to show that it is perfectly permissible for a person to read that, to read this claim in either way, contextually. In terms of context, we submit that there are much stronger reasons for construing it as a general rule. And the next point we make, I'm now on paragraphs 31 and 32.
It does limit the data when the rule is applied.
That's one way of reading it, reading the claim. And the other rule is to say limiting means really limiting. That you're not limiting if you're allowing exceptions. So on a road with a speed limit, that limit means everybody. It's not satisfied by if you ensure that one person on the road doesn't exceed the speed limit. The analogy is inexact.
Well, that's a bad example from your point of view. What about the police? Because there's a specific statutory exception saying speed limits don't apply to the police.
I did say it was.
They do apply to everybody else.
I did say.
Anybody who tries to say I'm not guilty of the offence because the police can exceed the speed limit is going to get short shrift.
I did say it was a bad example. I did say it was a bad example. I mean, I've been trying to avoid. I've been trying to avoid analogies for one reason, because the words of the claim say exactly what we say they are. Say they mean, and limiting can mean limiting.
Well, it depends. It's a composite phrase. It's means for limiting.
Indeed.
I mean, the means for opening the door include the handle, which does open the door when you depress it.
Yes.
But not if you don't.
No, indeed. And that's a different technology.
Mm.
That's a different technology, and the patent no doubt would explain the purpose of producing it. In this case, we agree that what we're trying to do is reduce the amount of padding in the system that's going over the air. Okay? So let us consider the rival construct this issue, the two possibilities, from the point of view of trying to reduce padding. And my learned friend says, he said, less padding is used in his footnote, which I embraced. And he said, orally, less than what? Less than the prior art. Again, I embrace that. We're looking at an invention directed at having less padding than the prior art. Okay. So, if you take my now we're considering: are you allowed to exceed the limit some 99 times out of 100 or not? On my learned friend's construction, if you're allowed to exceed the limit 99 times out of 100, then overall, over those 100 occasions or longer, you will have more padding than the prior art. So if one considers long term, his construction allows a system, covers a system.
Yeah, but it all depends upon what you mean by 99 times out of 100, because you're talking about different TTIs, whereas within a one TTI, the situation is quite different.
And what I'm going to do, so if you're now paragraph 32, what we do is in Little Roman 1, we consider long term, consider any period of time you want. And in Little 32, Little Roman 2, we consider a single TTI. So let me do one first. Consider the long-term view. It's undoubtedly the case that on his construction, the claim covers systems which use much more padding than the prior art, because they only very occasionally use these means, use these limits, and on the other occasions they use much, much more. So much more efficient, and it would be very odd if it covered that sort of system. Now let's consider a single TTI. Okay. Now we know, on his construction, the claim covers systems which apply the rule only in odd TTIs. We also know that in the prior art, there are occasional TTIs where the same result is achieved. we've seen DXX14. Okay? The DXX14 produces the same result as the patent, whatever you call the result. DXX14 produces the same result as the patent. So imagine, so his construction covers systems where the only time the rule is applied is in cases like DXX14. And of course, so that means in those TTIs when the rule is applied, there won't be less padding than the prior art, they'll be exactly the same. So what that means is, on his construction, the claim covers systems which never, ever, ever produce less padding than the prior art. His claim covers systems which sometimes produce the same amount of padding as the prior art, and on other occasions, 99 times out of 100, they produce more, maybe much more. That's the point in our paragraph, little Roman 3 on 32. That's the effect of his construction, saying that he's allowed to pick and choose when the rule is applied. It means that he covers systems that never produce less padding than the prior art on a TTI by TTI basis, and overall produce far, far more. And that just is not sensible. That's just not sensible. And it's not anything contemplated by the patent, which of course is just proceeding on the basis that this is a rule, this is how you're doing it. You're going to be using the next smaller ETFC as the size of your ETFC. No suggestion of exceptions or anything like that. And I've made this point already, but just to put it in its rightful place. My learned friend says that one might decide not to use the invention in specific circumstances. No evidence or finding of that. He mentions in particular urgency. There's no evidence or finding that the skilled person would think that there were any situations which urgency would require you not to apply this rule. That's just something that he's thought of. And there's certainly, obviously, there's nothing in the patent about any exceptions, urgency, or any situations where you might not want to run the rule. And of course, and again, this is a point I've made, but this is where it fits in. He makes it sound as though he's talking about the odd occasion, or on those occasions when it's urgency. But it is, as my Lord said, it is all or nothing. If he's right, it means you can construe the claim as covering a system which only does it one time in 100, which just has no benefit in terms of the invention. So I've developed the point in paragraphs 32, 33 of our skeleton, and that leads to 34, which I've also developed, which is that you can avoid reading the claim 1 onto the prior art by construing it as applying a universal rule. So if your lordships think that it's important that it would be odd to construe the claim 1 to cover that, then this is the correct way of doing it, and not by writing words into the claim. And then the paragraph 35 is simply the point which I've already made, which is they originally read claim 1 in the way that I'm now urging upon your lordships and your ladyship. We quote there again the text and underline the word cannot. And that recognises that integer 1f requires a consistent or universal rule, and obviously there's no suggestion there that integer 1f requires any specific procedure more specific than simply limiting.
Yeah.
And finally, in paragraph 36, we do say that this is new. We say it's new because of the pleading point. The pleading identified what they said the standard requires. So their pleading says the standard requires this. And if they were going to say that claim 1 required more than merely that the ETFC cannot exceed the size of the MACD flow data, they would have had to say the standard requires, and then inserted the words from paragraph 48 of their skeleton. And so it is a new point. It is true that the experts express themselves on occasion in ways which are consistent with what they're saying now. But that's very different from giving us notice that they were going to say that the claim specifically required this, and their pleading did the opposite. The pleading made clear that they would not be saying that Claim 1 required what they now say should be written into the claim via paragraph 48.
But in procedural terms, the whole issue in the case, or not the whole issue, a very important issue in the case was what did the patent mean? And they've got a single document. The question for the court is, what does this mean? Normally, as with any document, you construe a patent as a whole. So one claim can shed light on the scope of a previous claim in a patent.
Well, I certainly don't disagree with that.
So none of that's controversial, and although you have from time to time said that Mr. Speck offered to prove this, that and the other, there is no burden of proof on a question of interpretation. There is if you want to adduce background facts or things like that as aids to interpretation. But there is no burden of proof. And as my Lord Justice Arnold says, the court's not bound by what the parties think the document means anyway.
No, indeed. Of course, the position is different when we come to the question of infringement.
Exactly. But
Yeah.
that's your only point,
Oh, well,
isn't it? If the course of evidence on the question of infringement might have been different, well, maybe you've got a point. But simply to say, well, it's a new way of interpreting the patent, speaking for myself, I don't think gets you anywhere.
okay. So we do say, I won't develop any further. We do say in paragraph 36 that this way of interpreting the patent should have been notified to us because it is a matter on which technical evidence could have borne. But your Lordship is right. There is an even stronger submission, which I'm coming to, which is on infringement. They're in real difficulties, and I will come to that.
Yeah.
What I was going to do now is address the consequences of your decision, your Lordship and your Ladyship's decision on construction, in terms of the consequences in terms of validity and infringement.
In terms of?
Validity and infringement.
Yeah.
So let's start with, if you uphold the judge on the first construction, if you agree with what I've submitted about what paragraph 184 means and agree with that, then claim 1 is anticipated by filia trial for the reasons given in the judgment starting at paragraph 315. That's the DXX14 section. And I've been through that in detail with your Lordships, and I demonstrated that DXX14 shows not merely the same output coming out, but actually shows limiting being done. And we do say that the judge made a finding of fact of limiting, that filia trial discloses limiting.
It's not a finding of fact. It's, again, a question of interpretation. It's a document. He's construed the document.
Yes, what I meant is a finding of fact that having construed the document that way, and that construction is now not an issue, what I meant was it's a finding of fact that given that construction, the result would be an actual limiting. When that document is put into effect, the result would be limiting. And that is on the construction of the document, which is not controversial in this court. That's what I meant, my Lord. Thank you for picking me up. Now, what if you accept InterDigital submissions on the first construction issue? And that is, what if you accept that it requires actually identifying the next smaller ETFC and using that as a limit on multiplexing? Now, the key point is that InterDigital did not plead that the standard required any such procedure. And I've showed you that pleading. They simply pleaded that the size of the ETFC cannot exceed the size of the MACD flow data. And as a result, the question just simply wasn't explored by trial, and there was no finding by the judge that the standard requires that procedure. The formal position is that the judge made a positive finding that the patent was not capable of being essential. That's paragraph 325 of the judgment. And he made an order dismissing the infringement claim. So formally, that's paragraph 5 of his final order. So although we put in a respondent's notice putting this in issue, pointing this out, it's really for InterDigital to explain how they can, on what grounds your lordship should set aside paragraph 5.
But it's not an independent finding. On the contrary, as you point out in 325, he says, therefore, he says, I find the patent to be invalid and therefore not capable of being infringed or capable of being essential, which is obvious.
Indeed. But his,
it's not even if valid, not infringed,
no,
or not essential.
I understand. But if we go to his actual, and as your lordship points out, it was at paragraph 186 that he said that if valid, it would be essential.
Yeah.
Yeah. That paragraph is obviously 2 paragraphs after paragraph 184. So he obviously has in mind his construction of the patent, which is, as he says, any means which bring about the stated result. But in any case, of course, the fact is that because InterDigital never pleaded that the standard required their specific procedure, which they now ask your lordship to write into the claim, that wasn't something that was investigated at trial, as the subject of evidence at trial. I'm going to come in a moment to the evidence that my learned friend shows your lordships. Our position in this court is that the rules that they well, let's, if we can go, we should go. I should have this in front of your lordship. So if you go back to the pleading,
Back in supplementary tab 7.
Yes, that's right. Page 100 and.
Go back to page
107.
107.
Yeah.
Well, I think if we're going to embark on a detailed consideration of the pleading, Mr. Abrams, we might be better off doing that tomorrow morning. Good idea. How are we doing for time?
Yes, I'll be finished shortly in the morning.
Right. Thank you very much. I'm assuming that we will get soft and hard copies of this transcript that's been.
We can provide my lords and my lady with whatever you'd like. Certainly the skeletons and probably the judgment, but if there's anything else that you'd
I think we've probably been sent the skeletons in Word format.
I certainly have, yes.
Yes, I have too. And the judgment we can get off Westlaw or one of those things. But the transcript, I think we will want.
certainly.
You mean the transcript of today?
Yeah.
Yes, that's
Right, thank you very much. 10:30 tomorrow morning.